Hello, everyone. Welcome to the December webinar of the Task Force for American Democracy. I am Mary Smith, Director of the Task Force and a past president of the American Bar Association. Today, we are thrilled. You will hear from constitutional law expert Dean Erwin Chemerinsky as he discusses the cases from the 2024 to 2025 Supreme Court term that affect presidential authority and the balance of power among the three branches of government. During last term, in a sweeping series of rulings, the U.S. Supreme Court granted all 15 of DOJ's emergency applications. The Supreme Court's emergency rulings have allowed the president to rapidly reshape key federal institutions without full judicial review. By granting stays and lifting injunctions, often without explanation, the court has enabled the president to fire civil servants, restructure or eliminate agencies like the Department of Education, and enforce controversial immigration policies. There was also a dramatic increase in the Supreme Court's shadow docket or emergency docket, rising from 44 cases in the 23-24 term to 113 by July 2025, a substantial jump in just 1 year. The lack of explanation and limited briefing in shadow docket decisions means these rulings often lack public transparency and clear precedential effect on lower courts. The key cases for the upcoming term are also going to be previewed today, including the tariff case and the Birthright citizenship case. So with that, I'll just introduce briefly our esteemed speaker. I'm just going to give a brief background because if we actually talked about everything he's done, we wouldn't have time for the conversation. But Dean Chemerinsky became the 13th Dean of Berkeley Law on July 1st, 2017, when he joined the faculty as the Jesse Chopper Distinguished Professor of Law. He has had a long career in academia. He is the author of 19 books, including leading case books and treatises about constitutional law, criminal procedure, and federal jurisdiction. His most recent major books are Worse Than Nothing: The Dangerous Fallacy of Originalism, which he wrote in 2022, and Presumed Guilty: How the Supreme Court Empowered the Police and Subverted Civil Rights, and that was in 2021. He is the author of more than 200 law review articles, and in 2016, he was named a Fellow of the American Academy of Arts and Sciences. So with that, Dean Chemerinsky, welcome to our program. We're so thrilled to have you. We're going to save about 10 or 15 minutes at the end for questions, so you are able to ask questions, type them in the Q&A, and we will monitor them and try to answer as many as possible at the end of the conversation. So let's dive right in. Dean Chemerinsky, I want to start with a basic question. What is the state of jurisprudence on presidential authority, and are there any limits left on that authority?
First, let me say what a pleasure it is to do this with you. Thank you so much for inviting me. I think you asked two questions. One is, what's the law with regard to presidential power in terms of how it's changing? And second, are there limits? I think we're in the midst of a major transition with regard to the law of executive power. I think what you see now is a Supreme Court that's likely to embrace the so-called unitary executive theory. Let me explain this and why it's a shift with regard to presidential power. The unitary executive theory says that the Constitution vests all executive power in the president. So the president is in charge of the entire executive branch of government. In practical terms, that would mean the president can fire anybody, even agency heads, even civil service employees, where there are statutory protections against removal. The unitary executive theory, the phrase, comes from young lawyers in the Reagan administration in the 1980s, especially John Roberts and Samuel Alito. When the Supreme Court first considered the unitary executive theory in 1988 in Morrison versus Olson, the Supreme Court 7-1 rejected it. Chief Justice William Rehnquist, a conservative, wrote for the court, and said, we're a constitution of interdependent powers that check one another, not independent branches of government. Only Justice Scalia embraced the unitary executive theory. Now I think there's a majority to do so. And as we'll talk about, I think we're going to see it in terms of the ability of the president to fire any executive officials, even agency heads, where there's statutes that limit removal. So this is the transition we're seeing. And to put it most simply, it's a court that's willing to support much broader executive powers than we've seen previously under the Constitution. Are there any checks on presidential power? Of course. I think there's countless things that the president could do that the court would declare unconstitutional. But so far, this court with this president has upheld most of Donald Trump's actions since January 20th.
Well, thanks for that overview. That really kind of sets the stage. I'm going to go back not just to last term, but the previous term when the presidential immunity case was decided. And some would say that that case was the most consequential case the Supreme Court has decided for decades. Do you agree? And can you briefly tell us a little bit about the holding in that case?
I think it's an enormously important case. I don't know if it's the most important case in decades. I think the future will tell us that. The Supreme Court in Trump versus United States held that a president cannot be criminally prosecuted for official acts taken in office. It was a 6-3 decision. Chief Justice Roberts wrote the opinion for the court. Both Justices Sotomayor and Jackson wrote scathing dissents. Justice Kagan joined their dissents. Chief Justice Roberts said that the framers of the Constitution wanted a president who was able to act without fear of criminal prosecution. The dissenting justice said the framers of the Constitution wanted checks and balances. The framers of the Constitution believed that the rule of law means that no one, not even the president, is above the law. Will it matter with this president, with future presidents, that even if the president does something illegal, the president can't be criminally prosecuted? Justice Sotomayor gave powerful examples. She said, imagine the president orders the Navy SEALs to kill a political rival. Or imagine that the president takes bribes for pardons. Somehow neither of those examples seem so far-fetched at this moment. The president has absolute immunity. Justice Jackson, in her dissent in a footnote, says, no one disputes that the president can fire the attorney general. The issue in this case is, could the president order the attorney general assassinated and be immune from prosecution?
Yeah, that's the way that case came down. So I mentioned in my introduction a little bit about the shadow docket, which has really escalated, I think, since January. And you have written that you have been concerned about the shadow or emergency docket. Can you tell us a little bit about what that is and give us some of the statistics?
Of course. The Supreme Court has always had an emergency docket. Imagine somebody who's facing execution and seeks a last-minute stay. That's come to the Supreme Court. But what's changed over recent years is the exponential growth in the Supreme Court taking up matters on the emergency docket. My concerns start with there's not full briefing when the Supreme Court decides something on the emergency docket. There's no oral argument. The justices don't meet together and confer before they decide. And I believe those procedural aspects of jurisprudence are important. But there's other things about the emergency docket that are of great concern. I'm very worried that the Supreme Court is often deciding matters of life and death, matters about personal freedom, with no written explanation. Let me just give you a few quick examples, because it fits what we're talking about last term. One is a case, Department of Homeland Security versus DVD from June. This involves the Trump administration wanting to deport individuals from Venezuela and Cuba to South Sudan, a country where they had no prior contacts. Federal district court judge in Boston issued a preliminary injunction. The district court said, this violates the law. A federal statute prescribes where somebody can be deported to. The judge said he feared that these individuals face torture, even death in South Sudan. The United States Court of Appeals for the First Circuit didn't stay the preliminary injunction, it upheld it. But the Supreme Court, 6-3, stayed the preliminary injunction to allow these people to be deported to South Sudan. There was no majority opinion, not a word of explanation from the court. A blistering dissent by Justice Sotomayor. A second example of this was McMahon versus New York in July rather. This involved President Trump eliminating the Department of Education. Federal District Court said Congress created the Department of Education. Only Congress can eliminate the Department of Education. And the District Court enjoined the firing of over 1,500 employees of the Department of Education. The Second Circuit allowed this to stand, didn't stay the preliminary injunction. The Supreme Court 6-3 reversed, allowing the executive branch to eliminate the Department of Education, to fire these individuals. Again, no opinion, no explanation from the court, though there was a strong dissent. One more example, Nome versus Perdomo from Monday, September 8th. Federal District Court judge in Los Angeles found that ICE agents were stopping individuals without reasonable suspicion. The Fourth Amendment is clear that for law enforcement at any level, including ICE, to stop somebody, there's to be reasonable suspicion. The district court said that ICE was using 4 factors: somebody's apparent ethnicity or race, whether they spoke Spanish or had an accent, the kind of job they worked, and where ICE found them. And she said these factors, individually and collectively, don't add up to reasonable suspicion. She issued a preliminary injunction. The Ninth Circuit held an emergency hearing and upheld the preliminary injunction, 55-page opinion. The Supreme Court stayed the preliminary injunction, but no opinion of the court, not a word of explanation. Justice Kavanaugh wrote a concurring opinion for just himself. Justice Sotomayor wrote for the 3 dissenters. It's very troubling to me that the Supreme Court isn't giving any explanation in these cases. Because I said so wasn't persuasive to any of us as children, it doesn't become more persuasive when it comes from the Supreme Court. Opinions matter in indicating that it's not just arbitrary power, but a reasoned judgment. Opinions matter to give guidance to lower courts. I'm also concerned that the Supreme Court often, on its emergency docket, is ignoring detailed fact-finding from trial courts. It's no longer looking to whether there's an irreparable injury in deciding whether to give relief, which the law requires. So that's a short explanation of some of the things that bother me about the shadow docket.
Well, thanks for explaining that. And I just want to kind of make the point for our audience that these cases that are decided, most of the ones that you mentioned on the shadow docket, they're not final decisions. They were merely staying lower court decisions, but they had consequences like deporting people to another country or allowing the dismantling of the Department of Education. But does it matter now when the case may ultimately get up to the court on the merits? It may be years before it does.
Well, if there's a preliminary injunction, then the government action is stopped until ultimately the court can rule. But when the Supreme Court lifts the preliminary injunction, then the government can engage in its practice. Maybe later the Supreme Court will declare it unconstitutional, but all the while, then the unconstitutional practice continues. And in some instances, the Supreme Court is so indicated on its shadow docket what it's going to do when it comes on the merits that it's effectively deciding the matter just by how it resolves the shadow docket question.
Is there any period in history where the shadow docket has been used as extensively as it is now, or is this
No.
really uncharted territory?
No, the shadow docket historically has been very small, a couple of dozen cases a year. For October term 2024, that's last year, 140 matters were resolved on the shadow docket. That far exceeds by an order of magnitude anything we've seen before. And people will ask, well, why the tremendous increase in terms of matters on the shadow docket? Some of it this year is the many matters that have come bringing challenges to what President Trump has done. And when the lower courts have enjoined it, the government has gone to the Supreme Court. But I think the overall explanation is the shadow docket has increased because the Supreme Court has shown a willingness to rule on matters on the shadow docket. The Supreme Court doesn't have to rule at this stage. The district court issues a preliminary injunction. The Court of Appeals doesn't stay it. The Supreme Court doesn't have to take it at all. But the more the Supreme Court takes matters on the shadow docket, and the more it gives relief on the shadow docket, the more it encourages parties to bring cases to it on the shadow docket. And that's why I think we've seen the tremendous increase. The Supreme Court has shown a willingness to take and resolve matters on its emergency docket.
Well, that's really interesting. Well, I think one of the cases that was decided on the shadow docket was the administration has invoked the Alien Enemies Act to fast track deportations without due process. And I think one of the more dramatic cases was the midnight immigration case of Kilmar Abrego Garcia. Can you tell us a little bit about that case and what's the status today?
Sure. I want to separate the Kilmar Abrego Garcia case from some other cases that have involved the Alien Enemy Act. But let me start by just talking about what the Alien Enemy Act is. The Alien Act of 1798 says that if the United States is in a declared war or faces imminent invasion, then it can summarily deport, quote, males over the age of 14. The Alien Enemy Act has been used 3 times in American history before 2025. In the War of 1812, World War I, and World War II. President Trump, though, has invoked it to deport individuals, including Kilmar Abrego Garcia and hundreds of thousands of individuals, maybe, from Venezuela, including to deport them to a maximum security prison in El Salvador. Kilmar Abrego Garcia was taken to a maximum security prison in El Salvador. A federal district court in Maryland said there was no basis for this, ordered his return. The United States government went to the Supreme Court and filed a stunning and tremendously disturbing brief. The government's brief was that no federal court has jurisdiction over the matter because he's in El Salvador. To bring a habeas corpus petition, you have to bring it in the federal district where you are. And they said that the federal district court can't order the president to do anything in foreign policy. So the federal district court couldn't give any relief to Abrego Garcia, and it couldn't order the government to do anything. Um, the United States Court of Appeals for the Fourth Circuit ruled against the government, and there was a concurring opinion by a conservative judge, Judge J. Harvey Wilkinson. He's been on the bench for over 40 years, and he wrote a moving opinion of how the government's claim of power here is inconsistent with the Constitution and the rule of law. If the government can do what it was claiming, it could take anyone, Abrego Garcia, or you, or me, or any political opponent, move them to a maximum security prison in El Salvador, and then say, sorry, no court has jurisdiction over it. Ultimately, the Abrego Garcia got returned to the United States, and just last week he got released from custody. The Trump administration is trying hard to either prosecute or deport him, but so far, Abrego Garcia has won. More generally, there's a case, when it was decided by the Supreme Court in April, it was AARP versus Trump. It has nothing to do with the organization that protects seniors. It's just the initials of the person. And this involved individuals in Venezuela, from Venezuela, who were about to be deported to El Salvador. And the Trump administration was using the Alien Enemy Act. And the district court ruled in favor of the Trump administration and wouldn't give any relief to these individuals. The Fifth Circuit had not acted on it, and the Supreme Court at 1 a.m. on a Saturday morning, 7-2 ruling, said that the government could not deport any additional individuals under the Alien Enemy Act until there was an opportunity for the Court of Appeals to consider this. The Supreme Court reaffirmed that in May, and about 2 months ago, the United States Court of Appeals for the Fifth Circuit in a 2-1 decision said the Alien Enemy Act doesn't apply here. We're not in a declared war. We're not facing imminent invasion. And the Fifth Circuit will hear the en banc argument in that case in late January.
And have anyone been deported pursuant to the Alien Enemies Act, or has the administration abided by the court orders?
We don't know the answer to that question because we don't know what we don't know.
Mm-hmm. Well, that raises the question. The administration has flouted some lower court orders. I saw a study in the Washington Post. It's quite a few cases. And can you talk a little bit about that? And have they, to date, ignored any Supreme Court orders?
To my knowledge, based on public information, they've not ignored any Supreme Court orders. Now, to be clear, the Trump administration has prevailed in almost every case before the Supreme Court. The one we were just talking about, AARP being the exception. So there hasn't been much in the way of an occasion to ignore Supreme Court orders. There's certainly been compliance by the Trump administration with some lower court orders. I'm co-counsel in a case on behalf of University of California faculty and researchers who had grants cut off. Federal District Court in June found that the Trump administration violated the Administrative Procedure Act and the First Amendment and ordered grants be restored. And to a very large extent, they have complied with that court order. But I also saw the Washington Post story you mentioned of instances where the Trump administration has violated court orders. And that's very troubling because if the government can violate the Constitution and then ignore court orders to comply with it, then the government really could do anything.
Mhm. Well, do you think there's a risk that they're going to ignore the Supreme Court in the future, and then would we be in a constitutional crisis?
I think there's definitely that risk. President Trump said, and I quote, "He who saves the country violates no law." President Trump, in an August televised press conference, said, "I am the president. I can do anything." That's not a paraphrase, it's a quote. Vice President J.D. Vance said this past spring that the president doesn't have to comply with court orders that intrude on the president's powers. So there's certainly this threat of disobeying court orders. It's frightening because ultimately complying with court orders by the president is based on good faith of the president. I mean, the president can't be criminally prosecuted for contempt because the president can't be criminally prosecuted for official acts taken in office, where we started Trump versus US. If others who carry out the president's orders are prosecuted for criminal contempt, the president can pardon them. Civil contempt is where somebody is held in contempt, can be fined or jailed till they comply with the judge's order. But the problem there is civil contempt is carried out by the United States Marshals, who are under the direction of the Attorney General, Pam Bondi. So if the president were to choose to defy court orders and to say, "I'll pardon anyone who's prosecuted for criminal contempt," Pam Bondi's not going to enforce civil contempt, then we'll have a constitutional crisis of a sort we've never seen before in this country.
Mhm. How could us as citizens deal with that? Is there anything that we could do in that situation?
If the president openly defies court orders, my hope is that then even this Congress would consider impeachment and removal. We've never had a president who has done that. I know there's a story about Andrew Jackson when president saying, "Chief Justice John Marshall made his ruling, let him enforce it." But Andrew Jackson never actually said that. It wasn't attributed to him in about 20 years after his death. And while it was a terrible decision, a terrible conduct by Andrew Jackson, it was a court order that was directed at the state of Georgia. It wasn't directed at Andrew Jackson. He didn't directly disobey the court order in Worcester versus Georgia.
That involved the Cherokee cases,
Right.
right?
Exactly.
Well, you mentioned one of the cases that you're involved in where the administration terminated grants or contracts that had been authorized and appropriated by Congress. And I, frankly, just from me not being a constitutional law scholar, but I just don't understand how the president could terminate things that have been appropriated by Congress. What is the state of the kind of all the grants cases and contract cases that they've terminated?
This goes to where we started the conversation in terms of the actual increase in presidential power. Under the Constitution, Congress has the spending power. And it's always been thought that when Congress appropriates money, the executive branch has to expend it. Congress passed a spending bill, the president can veto it, but if it's adopted over the president's veto or the president signs it, the president has to send the money. He doesn't get another veto by choosing to terminate the funds and refusing to spend it. In the early 1970s, President Richard Nixon repeatedly tried to impound funds, refused to spend money approved by Congress. Virtually every court to rule, including the Supreme Court, found this illegal. In 1973, in Train versus City of New York, the Supreme Court found President Nixon's impounding of funds under the Federal Water Pollution Control Act was illegal. Additionally, in 1974, Congress passed the Impoundment Control Act. A beleaguered Richard Nixon signed it, and it prohibits the president from impounding funds. And yet, President Trump has impounded likely hundreds of billions of dollars of funds that have been appropriated. There have been two cases of significance that have come to the Supreme Court on this. One of these was Department of Education versus California on Friday, April 4th. What was involved here was the Department of Education cut off $65 million of teacher training grants. Federal District Court in Boston issued a temporary restraining order. The First Circuit said, we don't review temporary restraining orders on appeal. Wait until there's a preliminary injunction. But the Supreme Court, 5-4, stayed the temporary restraining order. The five in the majority were Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. Chief Justice Roberts joined Justices Sotomayor, Kagan, and Jackson in dissent. And the Supreme Court said two things. First, grants from the federal government are like contracts. Claims for breach of contract have to go to the Court of Federal Claims. And second, if the federal government has to pay this money, and that's later found to be an error, how will the federal government get the money back? The Supreme Court followed this in another case, National Institutes of Health versus American Public Health Association, on Thursday, August 21st. A federal judge in Boston, Judge William Young, found that the National Institutes of Health, in cutting off hundreds of millions of dollars of grants, violated the Administrative Procedures Act, that it was done in a manner that's arbitrary, capricious, and abuse of discretion. The First Circuit didn't stay the preliminary injunction, but the Supreme Court, 5-4, did stay the preliminary injunction. Again, same split as the prior case. There was a short per curiam opinion, and it said the same two things. One is grants are like contracts. Breach of contract should go to the Court of Federal Claims. And second, how will the federal government recoup the money? Justice Jackson wrote a scathing dissent. And in part, she objected to the Supreme Court was saying that the lower court should have followed what the Supreme Court had done in its earlier shadow docket ruling, California versus Department of Education. In fact, Justice Gorsuch in this latter case wrote a concurring opinion criticizing the district court for not following the ruling from the shadow docket. I think there's so much that's troubling about this. I don't think the Supreme Court is correct that these cases should go to the Court of Federal Claims. There's an Administrative Procedures Act claim here. There's often First Amendment claims that are present. Also, if we're going to talk about the irreparable injury to the federal government, shouldn't that be about a balance of equities? And what about the harm to the grant recipients that have their money cut off? What about the harm to the federal government when a grant is cut off midstream?
Well, it's interesting, Dean, where you said that particularly Justice Gorsuch and the majority in those cases on the shadow docket said their earlier shadow docket decision should have been followed. But traditionally, have those type of opinions had precedential value?
No. In fact, Justice Alito gave a speech at Notre Dame Law School in the fall of 2021 about the shadow docket. And one of the ways he reassured the audience saying, these rulings don't have precedential value. They're not binding on lower courts. But we've now had a couple of instances, one involving firing of members of the Consumer Product Safety Commission, Trump v. Boyle in July, another involving what we were just talking about, National Institutes of Health versus American Public Health Association, where the Supreme Court said to lower courts, follow what we said on the shadow docket. One of the things that's disturbing about that is that sometimes the shadow docket rulings conflict directly with longstanding Supreme Court precedent. Imagine you were a district court judge. What do you follow? The Supreme Court precedent or the recent ruling on the shadow docket? that doesn't explicitly overrule the precedent. It puts the district courts in a no-win situation.
I'm going to remind our audience that if you want to ask questions of Dean Chemerinsky, you can type them in the chat, but we're going to continue our conversation. Well, the interesting thing you just said, Dean, too, about those two cases you just mentioned, was that John Roberts actually joined the liberal justices. Can you explain that?
Chief Justice Roberts did not write a separate opinion in either of these cases. It's rare that he has joined the liberal justices in these shadow docket rulings. Um, but in both of these cases, he was in dissent. He didn't join the dissenting opinion. He just indicated that he dissented.
Mm. So it's unclear what the basis of his dissent was.
Yes.
Okay.
And it may be, I mean, in both cases, the dissenting opinions were very strongly written. In the latter case, the Nationalist Health case, this is the one where Justice Jackson, in her dissent, accused the majority of Calvin Ball, coming from the comic strip Calvin and Hobbes, and saying, there's no rules other than the government wins.
Well, this has been very illuminating as for the past term. Let's turn to the current term, and I know there's several cases pending that I think our audience is interested in that concern presidential authority. And let's start with the tariff case. Would you talk about what are the issues in that case and maybe make a prediction how you think the Supreme Court's going to rule?
Sure. There are two cases, and they were argued in November. Learning Resources Incorporated versus Trump and Trump versus VOS selections. The former comes from a federal district court that found the tariffs to be illegal, and the Supreme Court took the case before the Court of Appeals could hear it. The other is an en banc decision from the United States Court of Appeals for the Federal Circuit. Both found that the president lacked the authority to impose the tariffs under a statute. President Trump invoked the authority of the International Emergency Economic Powers Act. It allows the president to, quote, regulate importation. And President Trump said the power to regulate importation includes the power to levy these taxes. Both the district court in the former case and the federal circuit in the latter case said where Congress wanted to give the president the power to impose tariffs, it used the word tariffs in the statute. And in addition, they said that there's now a principle of administrative law that in order for the executive branch to act on a matter of legal or political significance, there has to be clear guidance from Congress, the major questions doctrine. And Congress didn't provide that here. President Trump is arguing that the statute does provide the authority for tariffs, and he's also arguing that as president, this is about foreign policy and he has broad authority. On the other hand, the argument is that Article 1 of the Constitution gives Congress the power to tax, and tariffs are a form of tax. Based on the oral argument, and I'm always reluctant to make predictions, I long ago learned that he who lives by the crystal ball has to learn to eat ground glass. But my prediction here is this is going to be an instance where President Trump loses in the Supreme Court. At the oral argument, Justice Gorsuch left no doubt that he's with Justices Sotomayor, Kagan, and Jackson. And the question is, will there be a fifth vote against President Trump? And my prediction is that there will be. Chief Justice John Roberts, I think, will be there, and maybe Justice Barrett.
That's interesting. Oh, and I want to make a correction. Type the questions in the Q&A, not the chat. I'm going to ask also about another case that the hearing was just recently, and it's Trump versus Slaughter. It's challenging the 90-year-old precedent of Humphrey's executor, which limited presidential remover power over independent agency heads like FTC. And you had alluded to this earlier, Dean. Can you explain the issue in this case and
Sure.
what direction you think the Supreme Court's moving in?
Sure. In 1935, in Humphrey's Executive versus United States, the Supreme Court held that Congress can create federal agencies, and Congress can provide that the heads of the agencies can be removed only for good cause. That case, you'll see ironically, involved a commissioner on the Federal Trade Commission, and the Supreme Court unanimously upheld the provision limiting removal. and the Supreme Court did so in forceful language. But this is part of checks and balances, but Congress carrying out its prerogatives. And this has been the law for 90 years. And then in May, in Trump versus Wilcox, and in July, in Trump v. Boyle, cases on the emergency docket, the Supreme Court stayed preliminary injunctions that prevented President Trump from firing individuals. And the Supreme Court said, both were 6-3, that President Trump was ultimately likely to win on the merits. Justice Kagan lamented this as implicitly overruling a 90-year-old precedent on the shadow docket. Well, Trump v. Slaughter involves Rebecca Slaughter, commissioner on the Federal Trade Commission. She has been confirmed by the Senate. She has a term that continues. And as I said, the law says she can be fired only for cause. President Trump removed her. The district court issued a preliminary injunction. The D.C. Circuit allowed it to stand. The Supreme Court stayed it pending the oral argument. And my sense from the argument, which was a week ago Monday, is that Rebecca Slaughter is going to lose and the Supreme Court's going to overrule Humphrey's executor.
So if that's the case, there was a reason why certain agencies are considered independent agencies, like the Federal Trade Commission, the Securities Exchange Commission, and others. If the Supreme Court does rule as you're suggesting, are there any independent agencies left?
Maybe the Federal Reserve Board, and that's going to be heard by the Supreme Court in January in a case called Trump v. Cook. I mentioned Trump v. Wilcox very briefly. This involved Gwen Wilcox, a commissioner on the National Labor Relations Board. Her term goes to 2028. She'd only be fired on the statute for cause. And it also involved Kathy Harris, the head of the Merit System Protection Board, the agency that exists to protect federal employees. She also has a term that continues, and she also can be fired only for cause. President Trump fired both of them. They went to federal court and got a preliminary injunction. The D.C. Circuit en banc ruled in their favor, but the Supreme Court stayed the preliminary injunction, allowing Wilcox and Harris to be fired. And at the end of a short opinion, the Supreme Court said, well, but the Federal Reserve might be different. It's existed since the first Bank of the United States. Why was the court discussing the Federal Reserve in a case involving Wilcox and Harris? I think it was to give reassurance to the stock market that President Trump couldn't go fire Jerome Powell. Well, President Trump did fire Lisa Cook, a governor on the Federal Reserve. He said it was for cause because she engaged in mortgage fraud. She's never been indicted, never convicted of mortgage fraud, but President Trump said so. And the question is, will her firing stand? Interestingly, in terms of procedural posture, she won in the district court. The Court of Appeals didn't stay the preliminary injunction, and the Supreme Court in this instance didn't stay the preliminary injunction either, so Cook has remained. In Trump v. Slaughter 10 days ago, there was a good deal of discussion at the oral argument about the Federal Reserve. And so I think that may be the unique, maybe there's some others, agency where the Congress can limit removal.
And is the statutory scheme for the Federal Reserve so different from the other independent agencies that the Supreme Court will be able to distinguish the Federal Reserve from the MSPB, the National Labor Relations Board, and the Federal Trade Commission?
The statutory provision is similar, in fact, identical. It says you can only have removal for cause. But the historical context is different in the sense that the Federal Reserve stems its origins back to the first Bank of the United States at the time of George Washington's presidency. And the goal was to have it have some independence from the presidency. And so I think a court where a majority of them think of themselves as originalists might be persuaded by that historic difference between the Federal Reserve. There's also the practical difference. There's a reason to have those who are deciding our monetary policy be independent from the president, as we're seeing now.
Well, that's interesting, Dean, because I know several of the conservative justices would consider themselves originalists, where they look at the statutory language, and you're saying that the statutory language for the Federal Reserve versus the other independent agencies is very similar, and they're going to rely on historical context. Isn't that against originalism?
I've long argued that the originalists on the Supreme Court follow originalism when it gets the results they want and ignore originalism when it doesn't get the results they want. Think of prominent examples. Citizens United versus Federal Election Commission. I challenge anyone to say, based on originalism, that there's a First Amendment right for a corporation to spend unlimited amounts of money in election campaigns. Or take the more recent case, students of fair admission versus President Fellows of Harvard College. There, the Supreme Court said that affirmative action violates equal protection. But the same Congress that ratified the 14th Amendment adopted many programs that were race conscious that today we think of as affirmative action.
Mm. Well, the final a couple final cases I want to, well, one is not a case, but the final case I want to talk about that's currently in front of the Supreme Court is the Birthright citizen case. Would you talk about that, what's the issue in that case, and how you think it'll proceed?
Sure, the case is Trump versus Barbara. It'll be argued this spring. When the country began in 1787, it followed English law that anyone born in the country was a citizen of the country. The Supreme Court tragically departed from that in 1857 in Dred Scott versus Sanford. There, the court held that enslaved individuals are not citizens, even if born in the United States. When the 14th Amendment was drafted and ratified a decade later in 1868, the first sentence of Section 1 unquestionably was to overrule Dred Scott versus Sanford. It says all persons born or naturalized in the United States and within the jurisdiction thereof are citizens of the United States under the state wherein they reside. In 1898, in United States versus Wong Kim Ark, the Supreme Court interpreted this provision. The court held, it was 7-2, that everyone born in this country is a citizen, regardless of the immigration status of their parents. The court said within the jurisdiction thereof was really meant to be limited to if it was an invading army and a foreign soldier had a child in the United States, or there's a diplomat or a child, but tragically also Native Americans were not deemed within the jurisdiction of the United States. But other than that, everyone else born in this country is considered a citizen. And thankfully, Congress dealt with the latter part of this in a statute in the 1920s. So since then, everyone born in this country is either a citizen of the United States with two narrow exceptions, a baby born to an invading soldier or a baby born to a foreign diplomat. But on January 20th, President Trump issued an executive order greatly restricting birthright citizenship. It essentially says only those born to citizens or those with green cards are United States citizens. Let me give you an example of what this excludes. Imagine that we have a student from a foreign country here at Berkeley Law, citizen of a foreign country, and she's lawfully here on a visa, studying for her advanced law degree, and she has a baby while here. Under the Trump executive order, that baby is not a United States citizen because she doesn't have a green card and is not a citizen. Every federal court to rule on this, federal district courts, federal courts of appeals, have declared the Trump executive order unconstitutional. I predict that this is one where President Trump is going to again lose in the Supreme Court. Usually he's going to win, but this is the second area where I said I think the court's going to rule against him. The history of the United States, the text of the 14th Amendment, Supreme Court precedent, long tradition support birthright citizenship.
Well, one final question, that before we go to questions from the audience, there's been a lot of news lately on the Venezuelan boat strikes, and we have not seen that go to court. Is there actual a judicial avenue to raise the issue of those Venezuelan boat strikes, or is there no judicial avenue?
I think it will be very difficult to have a judicial avenue in United States courts. Some of this is that the president has broad power as commander in chief to use American troops. Courts have been unwilling to consider the constitutionality of this. During the Vietnam War, there were over 24 lawsuits brought arguing that it was unconstitutional because the president was waging war without a congressional declaration of war. Every court, without exception, dismiss the case as a political question. Now, there's already been a proceeding brought in an inter-American court arguing that what's being done here violates international law. I'm not an international expert, but from my knowledge, it does violate international law. Whether the Inter-American Court can and will do anything is unknown, but I think it's going to be hard to bring challenges what the president is doing in federal courts.
All right, let's go to some of the questions in the audience. One question is, what are some of the court orders that the executive branch has violated, and how many do we think there are in total?
You mentioned the Washington Post story. There have been instances of federal courts ordering that funding be restored and that not having happened. And I don't know how many in all. And I do know of instances where the government has complied with those court orders.
Another question is that the our listener realized that we never really had a safety net for a dictator. It was always dependent on the moral character of the president, the Supreme Court, and Congress. And how do we fix this? And the person speculates the only way would be to start over.
I think the basis of the question is right and really important. One of the things that I've come to realize is how fortunate the country's been that we've really never had a demagogue as president who's shown no necessity of complying with the Constitution and laws of the United States. His chief of staff was quoted in the news yesterday as telling somebody he believes he can do anything. And that's what we've seen. And so I realized that we've been very fortunate historically in having presidents who've chosen to comply with the constitutional laws of the United States. We don't have a system in place that's ready to deal with a president if the president's going to systematically violate the constitutional laws of the United States. The hope is that our courts, including our Supreme Court, will be the guardrail for democracy. The hope is that Congress will ultimately assert its prerogatives rather than just roll over. Perhaps it's the people and their speaking out will make the difference for the courts, for Congress. But I've come to realize how much our system of government depends on the good faith of those who govern us, how much our system of government depends on their following norms. And if they're not in good faith following the Constitution, if they're not adhering to the norm of adhering to the law, then we never had to deal with this. And we'll see whether the system of government, whether the constitutional democracy is strong enough to withstand this.
The next question is, do you think Congress could consider or have begun to consider impeachment?
Impeachment takes a majority of the House and two-thirds of the Senate to remove. There's no way a majority of the current House is going to impeach. I mean, the current Congress has essentially been a rubber stamp for what President Trump wants. Might there be a point at which President Trump's actions are so egregious that a majority of the House might consider impeachment? That might it be so egregious that even two-thirds of the Senate would vote? It's conceivable, but it doesn't seem probable, at least on the horizon for now.
And there's a question. I know the Birthright citizenship case actually emanated from an executive order. Are there other cases in front of the Supreme Court that are considering the legality of executive orders?
Sure, many of President Trump's actions have taken form of executive order. Let me give an example that hasn't yet made it to the Supreme Court. President Trump issued a series of executive orders, and they were titled executive orders targeting law firms. So one of the first was against Perkins Coie, and the sanctions in it were draconian. It would essentially put Perkins Coie out of business. It said that no Perkins Coie lawyers can have security clearances, that Perkins Coie's lawyers could not enter any federal building, which seemed to include a federal courthouse, and the federal government would not contract with any client represented by Perkins Coie. What did Perkins Coie do to deserve that? Well, the executive order tells us it represented Hillary Clinton in 2016. There were then executive orders against Jenner and Block and Wilmer Hale, same draconian sanctions. This was because they had employed Robert Mueller or lawyers who worked for Robert Mueller. Then there was an executive order against Sussman Godfrey. What had it done? Well, it had sued Fox News, a case that settled for over $700 million. These are all executive orders. So far, every one of them has been enjoined by a federal district court, and it's on appeal, but I assume it will go to the Supreme Court.
The next question is, in your opinion, why do you think the Supreme Court ruled for presidents having unchecked power? This seems dangerous.
I agree, and I've thought a lot about this. One possibility is that the Supreme Court is worried that if it rules against President Trump, he will defy the orders, and that will ultimately undermine anything the Supreme Court can do. So rather than risk defiance, it's just ruling in Trump's favor. I know there are people who have said this. I'm more skeptical. I think the Supreme Court is ruling in favor of President Trump because a majority of the justices agree with President Trump. That I think by inclination, they see themselves as conservative and they see him as a conservative president. But I also think that they share his view of executive power.
Well, that's interesting, Dean. This is a question for me. By doing so, though, if they agree with him on the merits, but in doing that, they're also undermining their own power. Do they not see that?
Again, it's hard to answer. I think what you have in the dissenting opinions from Justices Sotomayor and Jackson, especially, but also recently, 2 weeks ago, from Justice Kagan, is they are really sounding an alarm that they are deeply concerned for the future of our constitutional democracy. The dissents are as strongly worded as any you will find in history. But so far, the six Republican appointed justices, six conservative justices, don't seem to feel that same concern. And I think, to go back to where we started the conversation, they're inclined, especially the Republican president, to favor broad, inherent executive powers.
Well, I know that I believe, at least personally, that Justice Roberts is an institutionalist and he does believe in the institution of the Supreme Court. As Chief Justice, how do you see him acting going forward to preserve the Supreme Court as an institution?
I share your perception that John Roberts cares deeply about the institution of the Supreme Court, but I also think he wants it to be the Roberts Court. And he knows that if he's in dissent in major cases, and he can be in dissent with five other conservative justices, it no longer perceived as the Roberts Court. I'll take as an example a case we talked about, Trump versus United States, that so broadly gave the president absolute immunity from criminal prosecution. Chief Justice Roberts wrote the opinion. Why did he write it that way? Why, even if he was going to rule in favor of Trump, not do so in a much narrower fashion? My surmise, and it's just that, a surmise, is that he knew that in order to have the majority opinion, he had to write it that way. If he didn't write it in that way, somebody else would have written it, and then it's not the Roberts Court. So I think John Roberts is an institutionalist, but I think John Roberts is also a pragmatist in wanting to be in the majority and to write the opinions that it takes in most of these cases to be in the majority.
Well, next question is there no statute restricting the power and reach of a president?
There's no general statute that limits the power and reach of a president. Of course, the Constitution is meant to do that. It is a constitution about checks and balances. I think part of the elegance of the Constitution is drafted that's underappreciated. So it generally requires two branches of government take any major action. It's supposed to be two branches of government to adopt a law, two branches of government to enforce a law, two branches of government involved to ratify, negotiate and ratify a treaty, or to appoint justices or ambassadors. And so it is a constitution of checks and balances. And there were important instances in the past where the Supreme Court has struck down presidential actions. So I think it's the Constitution that's meant to be the check, but there's no general statute that's a limit on presidential power.
Next question, now we have time for two more, is that during their confirmation hearings, Supreme Court nominees repeatedly state they will respect precedent. then they don't do that when they get on the bench. Have they committed perjury before Congress?
Perjury is intentionally lying under oath. When they say will follow precedent, were they intentionally lying under oath? Or was it their fingers were crossed behind their back? To be honest, I think they say what they feel they need to in the confirmation hearings, knowing they can do anything they want once they get on the court.
Last question from the audience is, there's a growing divide between the Supreme Court and lower courts. Where do you see this concerning divide going, and how can it be overcome, including the purpose of precedent?
I think that the lower courts are very upset by the large number of shadow docket rulings. They're very upset about rulings with no opinion, giving them no explanation, but then being told they have to follow it nonetheless. The New York Times had an article a few weeks ago, which was quite stunning in that many lower court judges spoke to the reporters and expressed exactly this. I think the Supreme Court can decrease the tension with the lower courts by doing much, much less on the shadow docket. And when it rules, giving explanations. Um, in terms of precedent, I don't think the Roberts Court is overruling precedents faster than other Supreme Courts have before. It's just doing so in much more major cases, like overruling Roe versus Wade.
Well, Dean, thank you so much. I wanted to give you an opportunity, like any final thoughts you want to leave our audience with before we conclude today.
I think what an unprecedented moment in American history. I never have been so afraid or imagined being so afraid for the future of American democracy. And I think that's a burden on all of us. I mean, to be informed, to find ways to be involved, to find ways to speak out. I think we will be judged in the future about whether or not we were silent and complicit and deserve to be condemned, or whether or not we really fought at this moment in time for American democracy.
Thank you, Dean. This was such an amazing panel. We are so thankful
My
to you
pleasure.
for sharing your insights today. And if you enjoyed this program, go to the Task Force for American Democracy's website at www.democracy-taskforce.org and sign up for our newsletter and our future webinars. Our next webinar will be next year on January 14th at 1 p.m. Eastern, and we will be joined by CNN commentator Ellie Honig, who's going to do a deep dive on everything going on at the Department of Justice and whether the department is still an independent law enforcement agency. So that's not to be missed. So thank you so much for joining us today, and wishing everyone happy holidays and a happy new year. And thank you, Dean Chemerinsky. Thank you all.